The 1965 Voting Rights Act, which has been correctly characterized as the most effective piece of civil rights legislation in United States history, was flawed in one important respect. It did not reach discrimination against the Latino voting community, which was facing, from Texas to California, throughout the southwestern United States, the same kinds of barriers to participation that the Black community faced in the South. But the 1965 legislation only prohibited voting discrimination on the basis of race or color, quote unquote. And in 1965, those terms, race or color, would not have included the Latino community. So in 1975, reauthorization of the Voting Rights Act included expansion to include discrimination against so-called language-based minorities. That included not only Latinos, but Asian Americans and Pacific Islanders as well. So with the 75 reauthorization, the Voting Rights Act came to cover discrimination in voting against all racial minorities in the United States. So actually, MALDEF led the fight in 1975 to expand the coverage under the 65 Voting Rights Act. Indeed, it was identified by our Washington, D.C. Regional Counsel, Al Perez, as a priority, and he convinced Vilma Martinez, our President and General Counsel, that this was the most important change in voting rights that could be made for the Latino community.
Starting in '74, we began to gather the facts with Southwest Voter Project, young attorneys, Tom Reston in Washington, D.C., and the MALDEF attorneys who were working here at the time, gathered all the information.
Here was the very big problem we faced. We needed evidence of voting discrimination. We knew it existed, but it had never been brought together. MALDEF's San Antonio office sent Modesto Rodriguez to dusty little towns all over Texas to uncover the evidence. Rodriguez is a true hero of the civil rights revolution, and the evidence rolled in floods, a seemingly endless string of devices designed to prevent Latinos from voting.
They would try to register to vote. All of a sudden, their forms weren't available. And on Spanish language television on election day, there would be public service announcements saying, do not vote unless you're duly authorized and qualified to vote, lest you subject yourself to fine and possible imprisonment. So that was the reality that many people were facing.
Section 203, the so-called bilingual ballots provision, was an important element of the 1975 reauthorization of the Voting Rights Act. The most important achievement was the expansion of coverage for the law to include anti-Latino voting discrimination. The 65 Act had only covered anti-Black voting discrimination because it prohibited discrimination on the basis of quote-unquote race or color, which did not include the Latino community. The 75 reauthorization, by adding protection for language minorities from vote dilution or vote discrimination, expanded coverage of the all-effective Voting Rights Act to include the Latino community throughout the country, but particularly in the Southwest from Texas to California.
Bringing the act to our community was extremely important. One, it signified to me, I wanted to make our community more visible nationally. Number two, it allowed MALDEF to become a national organization. Before that, it was strictly regional. And so when I got involved, MALDEF and myself got involved with the VRA, all of a sudden the New York Times, Washington Post, the Houston Chronicle, San Antonio, all these major papers were reporting on it and giving MALDEF a lot of play. So it made the organization much better known.
There was somewhat unexpected opposition from certain sources within the civil rights community that were concerned about opening up the Voting Rights Act too far and thereby giving conservatives a chance to restrict it rather than expand it, as was being advocated by MALDEF and others to include coverage of anti-Latino voting discrimination.
The NAACP opposed supporting what were called the Chicano amendments because his concern, and it's a valid concern, was that it would prejudice the constitutionality of the act, invite another challenge to the constitutionality to go all the way to the Supreme Court, and then it would all be lost for everybody.
The Shelby County versus Holder decision a 5-4 decision of the Supreme Court in 2013 effectively disabled Section 5 of the Voting Rights Act, which is the section that required certain jurisdictions to pre-clear or have a pre-review of any of their election-related changes. That was to ensure, by a review through the Department of Justice or the District Court in Washington, D.C., that the changes were not motivated by intentional racial discrimination and that they did not go backwards in their protections of voting rights. So that means that the most effective piece of the most effective civil rights legislation in our country's history was effectively disabled in Shelby County versus Holt. The biggest threat to voting rights in the United States today is the ongoing practices both in making it more difficult to register and to cast a ballot, and the creation or perpetuation of structures like at-large systems or unlawful redistricting that dilute the minority vote and make it really ineffective for people to cast a ballot. Those two different kinds of restrictions on voting being targeted at the growing Latino community because it is perceived as a threat to the existing power structure. MALDEF continues to centrally focus on voting rights as a part of our work because civic engagement is so critically important to the advancement not just of the Latino community, but to the thriving of our democracy as a whole. We have to ensure that everyone can participate and participate meaningfully, meaning that they can cast an informed ballot that has an effect on the outcome of the election. To do that, we have to enforce the voting rights wherever it is violated, whether that's by an undue voter ID requirement or an undue restriction on the ability to register to vote, or the perpetuation of systems, structures like at-large elections or unlawful redistricting that deprive Latino voters of the right to make a choice, an effective choice about who will govern. So we continue to make that work central to our civil rights agenda because of how critically important it is, not just to the advancement of the Latino community, but to the thriving of our democracy.